And I would like to now introduce tonight's speaker, Mr. Brian Thomas, who is an attorney from Preferred Physicians Medical, which is a physician insurer. And he's also on the board of the Anesthesia Patient Safety Foundation. He will present on the APSF position statement regarding criminalization of medical errors and call for action to prevent patient harm from error. He will also discuss systemic safety lapses and the normalization of deviance, which can contribute to errors. So at this time, I'll turn the floor over to Mr. Thomas.
Thank you very much, Dr. Kavanaugh. I really appreciate the opportunity to address your organization, Health Watch USA. As Dr. Kavanaugh mentioned, I am an attorney, but I am also spend most of my time providing risk management for specifically anesthesia providers and their groups. This topic obviously did not involve an anesthesiologist, but the Anesthesia Patient Safety Foundation felt that it was important enough, and we certainly have many other stakeholders involved in the APSF that we wanted to address that. So tonight, basically what I would like to do is go through a case that I'm sure most, if not all of you, are familiar with, and that is the case involving the former nurse RaDonda Vaught in Nashville, who was recently criminally convicted. And we'll take a look at a timeline. As far as our objectives, again, I want to review that case with you, provide you with a timeline, and I think it's important to note that the timeline has been published by a number of media outlets, so these are facts as reported, and I do not take any ownership and or represent that the APSF has put forth this information. This is all in the references at the end of the program. And then hopefully engage in some conversation regarding this important topic, and that's, again, the criminalization of medical error. And hopefully through our combined efforts disseminate this information. The APSF will be publishing an editorial. We've already posted this on our website, the full position statement and policy, and it will be featured in the next Anesthesia Patient Safety Foundation newsletter, which is now completely digital, and last data analytics indicated we had about 2 million visits to our website alone. So we are an international newsletter and is translated in 6 languages, including English. So with regard to the case, again, being in Kentucky, and I'm sure patient safety experts and probably many healthcare providers and clinicians in this audience, I suspect that most people have heard of this case, and if this is a little bit repetitive, I apologize, but I think it's important to put a timeline to the case because it has several takeaways that are both tragic, obviously, with regard to the events that led to the patient's death, and also with regard to the events that occurred leading up to the criminal prosecution and conviction of Nurse Vaught. And I do also want to state that Vanderbilt University Medical Center was at the heart of this case. We have colleagues with the APSF that practice and teach at Vanderbilt. It's an excellent institution, so this is by no means any type of criticisms other than, again, the facts that as they were reported in the media. So let's jump back into time a little bit. In December of 2017, Miss Charlene Murphy was a 75-year-old female. She had a subdural hematoma, came into Vanderbilt Medical Center. She had actually improved quite a bit, and this was a final PET scan that she was going to undergo before being discharged home. Nurse Vaught that day was serving as a help nurse or a float nurse, as it was described, and she was also precepting a trainee nurse. This was a situation that she was called away from her normal area where she was an ICU nurse and was on their way to the emergency department when the request came for her to administer some Versed to Ms. Murphy for her anxiety so she could undergo the PET scan. Nurse Vaught, thinking Versed, started with VE, went to the AccuDose machine and typed in those first 2 letters. She did not enter the patient's profile, and what she ultimately dispensed was vecuronium, which is an anesthetic agent, as most, if not all of you, are aware of. It's a powerful paralyzing medication used to induce general anesthesia. And this is a broad overview. We'll get into a little more detail as we look at the specific charges and the nursing board actions. But she administered the vecuronium erroneously and then left the patient with a radiology tech who then took the patient to the holding area where she was essentially unmonitored. Obviously, this led to a significant period of time in which the patient was not breathing and resulted in an anoxic brain injury. When confronted with this mistake, Nurse Vaught immediately accepted responsibility for the medication error when she was shown what she had administered. The following day, the family gathered to say their goodbyes to Ms. Murphy, and supportive care measures were discontinued. On that same date, two Vanderbilt neurologists reported a death to the county medical examiner, failing to mention the medication error or the medication mix-up with the vecuronium. The death was attributed to the subdural hematoma for which she originally presented, and the medical examiner ultimately determined that the cause of death was natural. Based on that, the medical examiner did not independently investigate the death. This medication error was also not reported to the state of Tennessee or the federal officials, which is required by both state and federal law, and also volunteer reporting to the Joint Commission, which was not done in this case either. Shortly after the events and the hospital's investigation, Nurse Vaught was terminated for her medication error. And again, there was a list of failures that the hospital provided her, steps and red flags that we can touch on a little bit later, highlighting the culmination of the errors that led to this very tragic accident and event. So the hospital did not report it to state or federal officials. We don't know why that did not occur. Vanderbilt in early 2018, again, we don't really have the specifics. Obviously, this was a confidential settlement, which the vast majority of medical negligence settlements are confidential, which precludes the parties, including the facility as well as the defendants, and presumably Nurse Vaught would have been included as a defendant since she was employed at Vanderbilt University at the time of this incident. They entered into, again, an undisclosed, and we certainly don't know the amount, but having about 23 years experience resolving and defending medical negligence claims, I can assure you that it was a significant settlement amount, probably in several $1 million would be my best estimate based upon the facts and the clear liability of a medication error. Again, those details were not published. So again, let's go back. So that was early 18, so nearly a year after the incident, 10 months or so, an anonymous whistleblower alerts the state and federal health officials about this unreported medication error. The Tennessee Department of Health was also concurrently, presumably, investigating Nurse Vaught, because whenever a nurse or a physician or a licensed provider is terminated and or loses their privileges, that is reportable in nearly every state and also to the National Practitioners Data Bank, which would have prompted the Tennessee Department of Health to open an investigation as to Nurse Vaught and any discipline that might arise from this medication error. Interestingly, and actually appropriately, based on my understanding of board investigations, the board decided not to pursue any disciplinary action because they found that her single act of negligence, although there was a series of mistakes and potential red flags that occurred during the medication error, did not constitute a violation of the state statutes governing the nursing profession. One of our senior claims attorneys came from the General Counsel's Office of the Missouri Board of Licensing for Physicians, and he agreed with this finding based on his several years as general counsel in investigating physician complaints in that state, and indicated that a single incident and or complaint involving a patient death typically does not rise to the level of discipline or sanctions, which in this case the board did not take against Nurse Vaught at that point in time. Fasting forward again, in 2018, Centers for Medicare and Medicaid Services, CMS, performs a unannounced inspection at Vanderbilt. They confirmed that this medication error had in fact occurred and that Vanderbilt did not report the error to the government or the medical examiner, according to the CMS report, which is also attached as a link in our references to this presentation. So based upon that investigation by CMS, they threatened to suspend Vanderbilt's Medicare payments, which is obviously would be a significant impact on their revenue. The facility responded with drafting, I believe, about a 105-page plan of correction addressing the errors that occurred here to satisfy the CMS investigation and inquiry. They initially declined to release that plan of correction, but ultimately through a records request, the press was able to obtain it. And again, a link to that lengthy document is attached to the references of this presentation. So spring of 2019, Ms. Vaught is publicly identified for the first time when she is arrested. So again, going back, the event occurred in December of 2017. She's terminated in January 2018. She is exonerated or not disciplined by the nursing board in October of 2018. She maintained her nursing license throughout that time period and in fact had regained employment at another facility in a non-clinical capacity, but still a position that required her to have her active nurse's license. She was identified again when she was criminally charged with reckless homicide, which is important that we'll get to, and impaired adult abuse. Again, these statutes are both felony charges. The court documents also identified her, and in some interviews in the press, the decedent's family members actually gave interviews indicating that their mother and their mother-in-law would not want Nurse Vaught to be criminally prosecuted. In fact, she would have forgiven her for this mistake. Again, in February of 2019, Vanderbilt finally comes out and their CEO makes some statements indicating that the death was not reported and their response was too limited. Also confirmed that they did reach a confidential settlement with the family. The licensing board for the facilities did not take any action against Vanderbilt. And again, I cannot speak to the level of that investigation or what other findings that they might have reached, but there was no disciplinary action taken against the hospital. Nurse Vaught makes her first court appearance in February 2019, pleads not guilty, and many nurses from around the country actually travel to Tennessee to show their support, as well as a significant outcry from the nursing community, as well as other healthcare organizations and patient safety organizations, including the APSF. So in the court records, they detailed a series of mistakes that led to the erroneous administration of the vecuronium rather than the midazolam. And that included, and I won't give you the entire list, but multiple overrides of the AccuDose machine warnings about this particular medication. At a minimum, there were 4 warning pop-up screens according to the report that accompanied her termination letter, indicating that the machine was notifying her that this was a paralyzing agent that apparently she did not recognize or place any meaning regarding those warnings. Interesting as well, the vecuronium needed to be reconstituted, which of course midazolam does not, which again was cited as another red flag that Nurse Vaught should have noted and should have alerted her that this was the incorrect medication. And again, the records also did confirm that she did admit her errors when she was confronted with the evidence that she had committed the medication error. At the prompting of the local law enforcement, the medical examiner changed the cause of death from natural to accidental. And interestingly, just shy of a year later, the Tennessee Department of Health, which oversees nurses licensing, reverses its prior decision and actually charges Nurse Vaught with 3 charges: 1, unprofessional conduct, abandoning or neglecting a patient that required care, and failing to maintain an accurate patient record. There was obviously the threat of the revocation of her license or suspension of her license and significant fines included in those charges. Again, no explanation as to why the Tennessee Department of Health originally, following their initial investigation, had found no cause for discipline. Ms. Vaught's attorney indicated in the press that he felt that the public pressure, as well as the pressure from the district attorney's office, and at that point, as those of us who watched the case closely were aware, the Tennessee Bureau of Investigation was also involved. I have no facts or evidence to support that, but that was what her attorney alleged resulted in this about face and the pursuit of additional charges against her professional license. As one could imagine, while she was waiting to go to criminal trial, she was also facing this administrative investigation and hearing process. So her attorney, correctly, in my opinion, as counsel, tried to delay the disciplinary proceedings until after her trial for fear that those proceedings could be used against her, which in fact they were. She provided over 2 hours of testimony to the nursing board where she, again, accepted full responsibility, but also pointed out the systemic failures at Vanderbilt University, which she indicated happened all the time, and every nurse was not only forced to do that, but there was a culture that, in her opinion, encouraged that in order to provide prompt care to patients. Unfortunately for Nurse Vaught and her attorney, she did not win that argument, and the disciplinary hearing went forward prior to the criminal trial. The board found that she was a threat to public safety, and therefore they could not wait until after the criminal trial to proceed with their investigation and hearing and ultimately their decision, which was to revoke her Tennessee nurse's license. They were sympathetic, but indicated that there were too many oversights, too many mistakes, and too many red flags. And also, interestingly, commented that this investigation was only within the scope of the proceeding limited to Nurse Vaught, and again, did not make any comments about the systemic failures that Nurse Vaught testified to at Vanderbilt. So again, she lost her nurse's license now a year and a half after she was terminated from Vanderbilt. So backing up just a bit, we skipped over COVID there a little bit, so things were delayed obviously on the timeline, but things started moving again in the criminal justice system as well as the civil justice system, and trials started to begin again despite the ongoing pandemic. Her trial was a jury trial in Nashville and Davidson County, Tennessee. Started on March 21st. Interestingly, while the prosecution called several witnesses, including a nurse who testified as an expert against Nurse Vaught, the defense only put on one witness who was also an expert. But it was a short trial. It was only a week-long trial, and ultimately the jury found Nurse Vaught guilty of criminally negligent homicide, which is a lesser included offense of reckless homicide, albeit still a felony with significant sentencing guidelines, and also the abuse of an impaired adult. Again, both felonies. Combined, she was facing upwards of 8 years in prison if the maximum sentence was imposed on both of those convictions. About a little over a month and a half, Nurse Vaught was sentenced on those convictions. This was live streamed. I actually observed via video conferencing the entire hearing. It was extremely emotionally impactful, both with regard to the tragedy of the loss of Miss Murphy. Her family, her 2 sons and daughter-in-laws testified, and again repeated that their mother would have forgiven Ms. Vaught and would not have wanted her to spend any time in prison, which I found rather compelling when the family is actually forgiving the defendant and not asking for any enhanced sentencing. Despite that fact, the prosecution again was looking for anywhere between 6 to 8 years to run concurrent on those charges. But after about a 5-hour hearing, including a recess, the judge came back and granted what is called judicial diversion in Tennessee, which essentially means that she was given 3 years probation on all charges, and if she completes that probation with no violations, then she will have her record expunged, although the court did note that she would never practice as a nurse in Tennessee again. Then, of course, the judge recognized the terrible mistake and consequences not only for the patient who tragically died in this case, but also the consequences for Nurse Vaught losing her professional license, her career, and then being criminally convicted for this medication error. So about April of 2022, Dr. Dan Cole, who is the president of the Anesthesia Patient Safety Foundation, asked if I would chair a task force of several of our APSF members, including patient safety experts, a patient advocate expert, multiple clinicians, anesthesiologists, pharmacists, CRNAs, and we gathered as a task force to draft and publish a position statement on the criminalization of medical error and a call for action to prevent harm from error. Several other nursing organizations, of course, the American Nursing Association, and many others have issued position statements and similar documents, but we felt as a Patient Safety Foundation that it was important for us to join our voice with those organizations and again try to disseminate this information and advocate for not prosecuting healthcare providers for medication errors. So these are some of the discussion points or the goals as we as a task force gathered and how we wanted to approach the position statement. The first that was noted was that not everyone knows who the Anesthesia Patient Safety Foundation is. Even some of the residents at a large facility in the greater Chicago area, one of our task members who's a critical care anesthesiologist and a professor indicated that many of his residents weren't even familiar with the APSF. So part of our position statement is obviously who we are. The APSF, for those of you who are familiar with the organization, was created about 35 years ago and was the first charitable organization to focus solely on patient safety. APSF started focusing primarily on anesthesia perioperative safety, but again, we have many stakeholders in our current foundation that represent multiple specialties as well as industry and folks like me who are risk managers and attorneys. So it's a very diverse organization with, again, many stakeholders. The APSF's vision statement that no one shall be harmed by anesthesia, again, has been expanded to include clinicians and clinician well-being. Obviously, in this case, there was a second victim, and that was Nurse Vaught, and that is not to take away from the tragedy and the loss of Ms. Murphy. The second point, again, was to ensure that our statement accurately and stridently reflected that we are deeply saddened by any patient death or injury, especially from preventable harm caused in a healthcare setting. We also, while we wanted to touch on the Tennessee case, we did not provide near the detail that I just provided with regard to all of the facts and the timeline. So it's a fairly short summary, but again, with those references noted at the end of the position statement for individuals who may want to review that in more detail. And then we really wanted to focus on what we can do with regard to a call to action to healthcare systems, professional societies, healthcare professionals, and appropriate government agencies to try to address these problems and continue to improve systems to prevent these errors from occurring. So why do we feel that this was an unjust prosecution? For a number of reasons. First and foremost, if you are familiar with the just culture model, David Marks has written on that topic, James Reason as well with the Swiss cheese model. The just culture model does not align with the criminal prosecution of what was determined to be criminally negligent in this case, but although she was charged with reckless homicide initially. And again, we want to support those individuals who are involved in these medication errors and provide education and remediation rather than punishment and punitive measures. That was one of the reasons we felt that it was unjust. Also, we feel it is extremely counterproductive to improving patient safety. Obviously, there's going to be a chilling effect. There already is. As I mentioned prior to the beginning of our presentation, I was in the great state of Kentucky last week meeting with two anesthesia groups comprising both anesthesiologists as well as nurse anesthetists, and I asked the groups if they were aware of this case, which of course they all were, and whether or not, if they were involved in a near miss or a medication error, they felt that they practiced in a facility or within an organization that had a just culture and a culture of patient safety, and that they could come forth with that information and be supported. And sadly, both groups indicated significant hesitation and did state that this case did have an impact on whether they would feel that they could disclose these errors or near misses and not face retribution either from the facility by way of termination or by the licensing board by way of suspension or revocation of their professional licenses or criminal prosecution, as occurred in this particular case. I didn't include it, but also I would add to that the great resignation. Obviously, clinician burnout is at an all-time high right now. Certainly nursing is at the top, if not the top, of the specialties who have been directly impacted by not only the pandemic, but this was a significant problem before the pandemic that's only been further exacerbated and amplified. So again, the negative impact on individuals who might have been considering pursuing healthcare and in particular nursing may have second thoughts if they feel that a human error and a medication error that results in patient injury or death could ultimately lead them to a criminal prosecution and facing prison time. And the good news is that fortunately these prosecutions are exceedingly rare. My company that I work for when I'm not representing the APSF has been in business about the same time as APSF, 35 years, and we have investigated over 16,000 adverse anesthesia events, and we've defended over 5,000 claims and lawsuits over those 3+ decades. And looking at our loss data, we have never had an individual insured, CRNA, or physician ever prosecuted criminally for medication error. And we certainly have had similar errors, maybe not as many red flags mixed, but we have had 4 transexemic bupivacaine mix-ups in the last 6 years, resulting in significant neurologic damage to patients that could have easily fallen into this type of fact pattern that a prosecutor may have felt rose to the level of a reckless disregard for patient safety and could have motivated them to pursue a criminal prosecution. So I'm certainly not suggesting that it can't happen. This case certainly underscores that it can, but I do want folks to appreciate that, at least from our experience, which is substantial, it is extremely rare. There was one other case in the mid-90s involving an anesthesiologist who fell asleep during a general anesthetic for an 8-year-old little boy in Colorado. He was criminally prosecuted and he was suspended, and I believe he did have his license revoked. However, he was found not guilty on all charges and ultimately did not face any criminal consequences for those charges. So again, very isolated, but there are a couple cases out there. So we also want to look at the bigger picture of what healthcare organizations can do. And again, in this case, I'm not sure how quickly there was disclosure to the patient's family. From our perspective, it should have been immediate. And obviously, disclosure to the appropriate authorities, that is mandated by state and federal law. And as was seen in this case, resulted in CMS coming in after an anonymous tip led them to conduct their independent investigation. And obviously the organization was facing significant penalties and possibly suspension of their Medicare reimbursement, which would have certainly been a significant blow to that fine institution. And again, to adopt and implement and actually foster a just culture culture of safety, as I mentioned, where individuals are not only feel that they themselves can report near misses or medication errors or any type of patient safety risk to the appropriate individuals within the organization and be supported and again remediated through education and not punished for that. So that is probably one of the biggest call to actions for organizations. And again, the information and the feedback from our groups last week suggested that there are many organizations that have not embraced a just culture or a patient safety culture in their organizations. And obviously learn from the techniques and technologies that are available. In this particular case, they had not implemented barcode scanning in the MRI and the radiology area in which this medication error occurred. We understand from the perspective of my company that it serves primarily private practice anesthesia groups. Many facilities, many practices do not have all of the resources that Vanderbilt's and Mayo's and Cleveland Clinic's have. But again, to the extent that those institutions can implement those technologies and techniques, will go a long way to prevent these from occurring in the future. And again, review the extensive implementation and implement rather the corrective plan of action that the CMS came up with for Vanderbilt. And then we've asked healthcare individual professionals themselves what they can do within their own practice as well as within their organizations to try to, again, not only foster a culture of patient safety, but also to look at their own practices and their own organization systems and try to identify those systems that may contribute to these medication errors and failure to monitor that occurred in this case. So again, these are some suggestions that are in the position statement. The override was clearly a normalization of deviance, which again is a concept that is born out of the NASA shuttle tragedies, both involving the O-rings failing as well as the foam breaking off. There was an article published in Anesthesia and Analgesia by Dr. Prelip, who was formerly on the board of directors of Anesthesia Patient Safety Foundation, and two of his colleagues that speak to the normalization of deviance, in which individuals that basically practice in a manner in which jeopardizes patient safety, but they become accustomed to it or normalize it because there is no bad outcome, when they should really be asking themselves, does that practice increase the risk to the patient safety, rather than saying, I've done this 1,000 times and nothing negative has happened. So Dr. Kavanaugh had mentioned COVID right now and the failure for many facilities and other organizations to insist on wearing N95 masks, which are now widely available, where now many institutions and organizations and healthcare facilities may not require that, even though those supplies are available. And that certainly could be deemed a normalization of deviance. And again, letting down our guard, if you will, just because everyone is now becoming more accepting that COVID is something that we're just going to have to adjust to and live with. So those are some examples. Obviously, overrides, if that's happening and it's happening on a routine basis, that is certainly was a contributing factor in this particular case and clearly appeared to be ongoing for a significant period of time and by many other nurses other than Nurse Vaught. So those are some of the risk management and the strategies that we have put forth for not only organizations but individuals to, again, try to essentially not override except in cases of an emergency and then have a double verification system. Obviously, in this case, Nurse Vaught did not see the multiple high alert warnings for the paralyzing agent. Again, she didn't have a good explanation other than she was distracted. She had a trainee with her and she was on her way to another assignment in the emergency department. Not an excuse, but again, applying the Swiss cheese model, one can see how that perfect storm can align. And even when a well-intentioned healthcare provider who's clearly trying to assist and aid and help the patient made a series of significant errors that resulted ultimately in her death. And again, do not contribute or enable There were many other nurses who testified in her hearing that indicated that they also had overrode the automated dispensing cabinets at Vanderbilt and other facilities. So again, to try not to enable that, even if you're not engaged, and then again, try to foster that culture in which others can speak up and report these matters to the organization so they can be addressed and these medication errors can hopefully be prevented in the future. With that, I will open it up to questions or comments or dialogue.